Remember, as a meeting with the attorney that we have to review.
We had one. Was today voting day?
It is.
Today's a voting day, right?
Yes, sir.
Did you vote? Son,
You're under
did you vote?
Yes.
You can disclose this. You don't want to disclose who you voted for, what you voted for necessarily, but you can disclose. It's public. It's a public record if you, it's actually a public record. So are you, you're a resident of Jefferson County, right?
I do reside here.
And the good news is you have all day.
You would certainly not be the one who would set a bad example, would you?
State your name, Mr. Hines.
Gregory Hines.
Argument.
Yes, Mr. Hines is 62 years of age. He is a Detroiter. Lives in Detroit, has so his entire life. He does have a child. For those 62 years.
Excuse me.
Bless
I'm
you.
sorry. One second, please.
Okay.
Continue, please.
Okay, Judge, and out of the 62 years, he does have the one child. He does have some priors. Judge has a 1990 CSC3, which I want to point out, but that's 1990. Or was I at 90? Judge, he's not working right now. One of the things that they informed me, the complaining clinician, Judge, she is addicted to narcotics and has certain episodes and certain spells, and it's rough. Like he said, if you were to talk to her right now, she'd be perfectly fine. But Mr. Hines is in Wayne County Jail, so he's not fine. So we have to think about the bond, Judge. It's $50,000 cash. I'm asking the court respectfully to consider reduction, no contact, GPS tether, just house arrest, Judge. No need a curfew because he's not working right now. So I'm asking for a reduction. This is an FA A and B case. 4-year felony, Judge, misdemeanor. So in terms of, even if he was to be convicted, he probably wouldn't really do any jail time. Probably would do some probation. I'm not saying he's guilty of anything, but that would be the realistic outcome of this, Judge.
Argument.
Judge, Mr. Reagan says defendant isn't fine because he's in jail. Let's just address why he's in jail. Because he ended up taking a stick, some type of object, and then beating the complainant multiple times. And then whether or not he got tired of using the stick or not, he ended up picking up, allegedly, at least from what I see, any other thing he could find to strike the complainant, including chairs and televisions. And then when he got done using all of those, then he ended up deciding to use his fist and kick her. And then he slammed her head in the wall. Judge, I think there are a couple of telling things on top of that in the last page of the report. One of which was after she had locked herself in the room to call 911 because she was scared for her life. Prior to that, the defendant had threatened to throw her out a window. In addition to that, Judge, we have that not just swelling, and I think this is another telling, a large amount of swelling that the police ended up finding on the complainant's face and head while taking her statement. I know, it was said in 1990 what defense counsel was doing. Well, in 1990, for this defendant, what he was doing was being convicted of CSC 3rd degree, criminal sexual conduct 3rd degree. That was one of his convictions, on top of many others that he had subsequent to that.
What is the current bond? 50,000 cash?
50,000 cash, Your Honor, surely.
Court ever heard the arguments of counsel? Court finds by clear and convincing standard that the defendant is a there's a danger to the complaining witness, even though this bond is unaffordable, the bond will continue.
Judge, I apologize, and I don't ever want to interrupt the court, but I would note that, you know, there was a lot of talk about beatings and all of this other stuff and chairs and sticks and you know, sounding something like a GBHA whim to me when we only here for a 4-year felony for felonious assault. And I do look at everything, Judge, the way the prosecutor decided to charge, what the possible penalties will be, what he may be looking at, Judge. And now he's been sitting in a jail for a few days thinking about that. Now, and again, Judge, I do understand your job is to protect the complaint as well as the community, Your Honor. But, you know, at the end of the day, Judge, even if he stays in jail a week, 2 weeks, even if he pleads guilty, Judge, he's going to probably get probation, be out on the street again. So, you know, I think that a tether, no contact, Judge, in this case could suffice because I think ultimately that's what's going to happen. I just don't think.
With your argument, the bond will be reduced from 50,000 cash to 50,000, 10%, and a no contact provision.
Thank you,
And
Your
a
Honor.
GPS tether, and a 10 p.m. to 6 a.m. curfew. Right.
Can I say something? Can I say something, Judge?
Sure.
This chick here, she's my friend, man. But she spazzed out and she overdid some things that she said I said. But did they look at me? She hit me first. She hit me with the stick first. And I snatched it from her and I did hit her. I'm a man of God. I'm a tap dancer of God. My name
Gregory
is
Hines, tap dance.
Dancer of
Gregory
God.
Hines.
But,
So what we gonna do?
I noticed that.
I'm
Okay,
glad you're-
all right, that's enough.
We-
That's
we
enough.
wish
Thank
you
you
the
very
best of luck, Mr. Hines.
Thank you. Good luck, Mr. Hines. Next case,
Best of
please.
luck. Best of luck, good brother. Best of luck to you.
Trial. Mr. Lebo has been able to talk to Mr. Davis Jr. And we are asking for. It looks like we're requesting an adjournment to receive and review some records. Mr. Lebo has advised that we need to also have further discussion, and we need to be able to get those records over to the prosecutor for review with regard to why and how the situation may have occurred.
Any objection? No objection, Your Honor, but I do want to address bond before we conclude this one. All right, go ahead. So the community corrections report that we have is labeled as a progress report, but I guess without a medical necessity letter, Mr. Davis should not be testing positive for THC, given that this case involved a crash and I guess some apparent psychotic type behavior and THC involved in this incident as well. So I just wanted to follow up on that and see what his status is.
There is a progress report dated November 1st, 2023, which indicates that he's tested positive for THC on October the 5th, October the 11th, and October the 24th. Defendant was arraigned on October the 4th. At that time, he was told that he could not have any alcohol or drug usage, and he seems to be still testing positive.
Excuse me, Your Honor. I'm his mother. I'm his guardian. When they had put that order in, prior to that, he did smoke some marijuana. But after that, he hadn't smoked any because he had been with me. And I had explained that to Miss Keller. So she said it must have been still been in his system because he literally been with me and my mother. So
Ma'am, do you have a legal?
I have legal guardianship. I submitted my paperwork to Mr. Lebo and Miss Shantae, the prosecutor. I was trying to get in contact with her, but I had emailed both of them my paperwork. Miss Shantae never reached back out to me. I also submitted the paperwork, his discharge paperwork, because the day that incident happened.
Okay, Miss Davis Jr., just be careful here. We don't want to get into the facts of the case at this time. That's part of why we're asking for an adjournment, so that Miss McDuffie and I can review that stuff with Mr. Lebo, okay?
Okay.
And ma'am, although he has a guardianship, you can't just speak on his behalf. That's for his attorney to do, so you need to communicate that through his counsel.
Okay.
Okay? All right, I will grant the adjournment and my concern, just so that you both know, is that on October the 20th, he tested negative and then began to retest positive again for THC. So that should not be happening.
I'm explaining that I have real bad depression and anxiety, so that's that's why I didn't smoke no weed and I didn't have edible. It was in a tea. It was into a tea.
Well, you can't have it in anything, sir.
Okay. And my anxiety flared up and my depression kicked in, and I just used that for my anxiety and depression. I don't use it for recreational use or anything else. It's just for my anxiety and depression.
Sir, unless you have a card, you can't use it. So if you use it again and you're not supposed to, your bond can be revoked. Do you understand?
Yes.
You know what bond revoked means?
Yes. And it's still
Mr. Davis Jr., just if you need to smoke, you need to get a card. You need to get letters to us providing that that's what you need it for. Okay.
Okay.
All right.
All right. So as to your request for adjournment, is November 28th enough time for you to do what you need? The next date after that is not until December 12th.
I think the 11/28 date should be fine, Your Honor. It sounds like we do have some of that, a lot of that medical paperwork to provide to Ms. McDuffie. So I think that should be sufficient. Thank you.
November 28th, 2023 at 9 a.m. Bond is continued.
Okay.
Thank you.
You're welcome.
Thank you.
Look where it says rename.
I don't even see my name.
Should say mute, stop video, chat, pin, rename.
No, I don't even see.
I think when it's on your device, you have to go to your settings.
My settings. Let me go ahead and do that real quick. I apologize.
Who are you?
Mr. Hewitt, please start your video.
My name is Francisco J. Melcher.
Oh, he's my MTR. You need to be in court in person, sir. You have an hour to get there.
I don't live in San Antonio. I live in Eagle Pass. I'm working as a medic over here. They told me a Zoom meeting.
MTRs are required to be in person.
That's what my attorney had told me. She even sent me the meeting, Zoom, and stuff.
So
I wasn't even.
You want me to tell the judge you won't be in person?
If possible. I mean, my attorney just told me that it was on Zoom.
I know, but your attorney was incorrect. The judge requires that you be in person.
Okay. Let me text my attorney because I wasn't even aware I had court today.
So why are you here?
I'm sorry?
If you weren't aware, you had to have been aware that you had court today if you're here.
Yesterday, I had to find out through the bail bonds. And then I texted my assigned attorney and she's all like, yeah, it's on Zoom. I was like, I wasn't, because I have court in Eagle Pass today as well.
Well, you have to get a reset, but you're going to have to appear in person.
Okay. Should I make my attorney aware? Her name is Brenda.
Yes, she should be aware, but you can let her know. But you can't leave until you get a reset date and permission from the court.
Okay, ma'am.
All right.
Yes, Marie.
Francisco Melchor is an MTR that is on our docket today. His attorney, Brenda Levinston, sent him the Zoom information. He's a medic in Eagle Pass, and he said he wasn't aware of his court date until yesterday when his bondsman told him, so he is not in person in the courtroom. I told him I would let you know, and we'll probably reset this case, but I just wanted to advise you that he is an MTR that is appearing on Zoom.
I see Mr. Melchor. Mr. Melchor, I see you're not at work. I don't think that that's your house, right?
Yeah, I have court here as well today.
Where?
For a traffic ticket.
Okay, and what time?
At 10:30.
Okay, when you're done there, you're coming here. Okay? So,
Okay.
And Your
we
Honor,
need to
he
see-
also does not have permission to be an Eagle Pass. He does not have a travel permit. I know the MTR is pending, but he is still on probation until June, and he left the county without permission.
I wasn't aware of that. I'm sorry. I didn't mean to do that.
well, I bet you signed paperwork that told you that.
You sure
Because I couldn't find a job over there.
Well,
And
now you're telling me why you left the county as if you knew. So I don't want to hear any of that till I see you in person in this courtroom. If you don't show up in person this afternoon, Mr. Melchor, the court's going to issue a warrant for you. Do you understand that?
Yes, ma'am.
All right, we'll see you this afternoon in person.
Yes,
You're
Your Honor.
excused now. Go take
Thank
care of
you.
your ticket.
Yes,
Thank
ma'am.
you.
Who else needs to make an announcement? Okay, we're just waiting on a prosecutor to come out so we can do Mr. Martinez's plea, and we can and we can excuse Mr. Tochi and his client after that. But we need a prosecutor out here.
Excuse me, Your Honor, I
Yes, ma'am.
just for the court on Mr. Francisco Melchor.
Melchor.
Melchor, I'm sorry. Just so probation knows as well, on September 29th, I called the bondsman and I had their number listed in Mocha at 3:19 p.m. I spoke with Monica and advised of MTR court date of October 24th, 23 at 9 a.m. Defendant is to physically report to the courtroom.
Okay.
Yes, and he failed to report that day, and because he didn't have an attorney, the judge reset him to today. And I think he had plenty of notice, so, and he wasn't supposed to be in the county. So I'm documenting that on my system, Your Honor.
Thank you very much.
Oh, that's right. He had subsequent, but he knows his MTRs are in person.
Yes.
Well, he's playing dumb today.
Your Honor, Donna Hurd's out. So we
All
can-
right, Donna, are you ready to proceed on a plea hearing on case number 662462? Mr. John Martinez, represented by.
Judge, I believe Ms. Lugo is under a court order to not have contact with the children.
With the children, he has the kids.
Yes, ma'am. She is actually, so the court is aware she is on a felony supervision of her own that directly involves the children. So I think you can still admonish him. I'm not sure how long that will last, and they will have children for years.
Okay.
So, but just so the court is aware, she is not allowed, my understanding is to be around the children. She is on probation for actually causing some injury to them.
Okay. All right. So keep your kids away from her, Mr. Martinez. One, but two, you can have no harmful or injurious contact with her. So that means that you can't make her feel as if you could hurt her or injure her or offend her. Because if you do, she's going to drop a dime on you, as they used to say, because it used to cost a dime to make a phone call. But she's going to call in on you and she's going to complain, and it could jeopardize your probation. Understood?
Yes, ma'am. Just to let you know, I haven't talked to her or seen her in the last since the 2020 case.
Okay. Yes,
Your Honor.
Officer Martinez. Officer Martinez, I'll hear you.
Your Honor, I think the court is being given incomplete or incorrect information. Mr. Martinez was on probation for assault, family choking, strangulation. Ms. Lugo was the victim. He is to have no contact with her as part of that felony probation. That felony probation expired in 2020 when he stopped reporting. They were both under the scrutiny of CPS. They were both non-compliant with CPS. The children were moved from both of them and placed with the defendant's grandmother, who they are currently residing with as of 2020 when the MTR on the felony case was filed. He is not to have any contact with Ms. Lugo. I understand it's a no harmful injurious contact in this case, but in the choking strangulation, she was also the victim in that case. There was no contact. And I don't know if he actually has the children right now or if the grandmother still has the children, but it seems like this behavior has been going on since 2017 when he was sentenced on the felony case, and he is pending MTR on that case. It has expired more than 3 years. I don't believe they're going to be able to continue him, but he has not been reporting to felony probation as defense inclined the court to believe. He has not been seen by probation since 2020, and he was not compliant on that felony probation.
Mr. Martinez, where are your kids?
My kids are with my mom right now, but I do help her with them. I see them all the time.
I don't know that CPS is aware of that because according to my report, both parents were non-compliant with CPS.
Mr. Martinez, I'm not here to play games. And the court does not look kindly on misrepresentations. And when you don't tell me everything, that's a misrepresentation. The no contact, that no harmful or injurious contact order is going to be changed to a no contact order. I don't know when they're going to make these babies, Mr. Tochi, but it's not going to be on my watch. Now that I've changed that, Mr. Tochi, is he still wanting to take this plea or not?
He is, Judge, and I do think there was some confusion. Yet John definitely has been checked out from the felony court for quite some time. I certainly didn't intend to make the court think he's been compliant for the last 3 years. He has not. I have worked out a deal with the felony prosecutor in the 290th, and this case right now is part of that deal.
Okay.
To get him some supervision and to try to keep his boots on the ground. Okay. He has no relationship with the complaining witness in this case. And my understanding in talking to his mother, I don't have the CPS records, but my understanding is they have been with her for quite some time.
And so they've probably been with her under a safety plan, Mr. Tochi, which expired within 30 days. And then what happens is CPS doesn't follow up with any court proceedings when they feel that the person taking care of the children can protect them from further harm.
Is probably what happened. So I believe the children have been with his mother for quite some time. And John has he's got a relationship with the children. The complaining.
They're going to have to deal with CPS on their own. I'm not a CPS court, but I am a family violence court, and I'm going to institute a no contact order with Yola Lugo.
We're fine with that. He was not going to have contact with her anyway, Judge.
All right. So, Mr. Martinez, what that means is that you are to stay 1,000 feet away from Miss Lugo. That's the distance of about 3 football fields, end zone to end zone. And had the Cowboys been able to run that 3 times, they would have won the game against Philadelphia Eagles. But they couldn't. So it's the length of 3 football fields, which is about 3 city blocks. You need to stay away from her, from any place she's at, from any car, any motor vehicle that she's in as a passenger or driver. That means motorcycles, boats too. You are to stay 1,000 feet away from anywhere she lives or is visiting. 1,000 feet away from any place she works, goes to church, from her family, pets, friends, co-workers, and neighbors. You are prohibited from making a single phone call to her. You are also prohibited by court order from texting her. And you're prohibited from sending her any type of message via any social media app. I'm going to throw in there courier pigeon and by any type of water lamp messaging.
I understand that.
Any way. You are prohibited from sending her anything from through the U.S. Postal Service, FedEx, UPS, Amazon, or any other type of courier or delivery service. And you can't use another person to try to communicate with her to violate this order. Do you understand that, sir?
Yes, ma'am.
All right. The BIP course, I'm going to give you 1 month to get enrolled. So 1 month would be December the 7th. And you're to enroll at a very specific BIP course. That's the Optimal Counseling Services. And you're going to talk to Dr. Alicia out there. It's a trauma-informed and trauma-based BIP. So that's why we're using it. They came in and showed me proof. And no one else has, that they're trauma-informed or trauma-trained. They tell me they are, but I haven't seen proof of it. So that's where we're sending our folks, over to Optimal. Compadre y Compadre is the parenting class for men. It's an award-winning class, Mr. Martinez. You need to complete that. Let's see here. Everything else is self-explanatory. Any questions so far, Mr. Martinez?
No, ma'am.
Okay, so the court is going to approve your application for probation, and the court is going to find you guilty of the assault bodily injury married offense alleged to have occurred on the 5th day of June of 2020 in case number 662462. The court is sentencing you to 1 year at the Bexar County Jail, but probating that sentence for 24 months of community supervision. You are ordered to, or the court assessed a $500 fine, but is not imposing the fine because the state has agreed to probate the fine in its entirety. So you have a zero balance of a fine, Mr. Martinez. You are ordered to pay court costs, and the court is issuing the affirmative finding of family violence. Mr. Martinez, that finding will be issued today immediately following this proceeding. That will be manifested through a court order, and the order is going to prohibit you from possessing, purchasing, owning, or using a firearm, a gun, and ammunition. Mr. Martinez, do you own or have access to any firearms, guns, or ammunition aside from the weapon that is in the custody of the Bexar County Sheriff's Office that we're going to get to in a minute? Anything else that you own or have access to?
No, ma'am.
Okay. Today, sir, it will start to be implemented. You are prohibited from staying anywhere, living anywhere, visiting any location where firearms, guns, or ammunition can be found. You are prohibited from being a passenger or driver in any motor vehicle in which firearms, guns, or ammunition can be found. And we're not restricting your right to hunt. We are restricting how you hunt. You cannot use a firearm, gun, or ammunition to hunt. With any question about that?
Yes, ma'am.
You have a question? What is your
No,
question?
no. I meant to say yes. I understand.
Okay, so Mr. Martinez, the court is also ordering and instituting a no contact order as between you, John Martinez, and Yola Lugo, and the court has already explained to you what that no contact order means. You are ordered to complete the BIP class, that's the Batterers Intervention Prevention Program, at Optimal Counseling Services, and you have until December the 7th to register for that class. You're ordered to complete the Compadre Men's Parenting class. You're ordered to submit to a drug test as soon as possible at adult probation. If you come up clean, then the court will not order you to do a TAP evaluation and follow recommendations. If you turn in a diluted or dirty or questionable drug sample, then you will have to submit to a TAP evaluation and follow recommendations. That's the court order. You are ordered to pay $100 to the Crime Stopper Fund and $100 to the Battered Women and Children Shelter. You are ordered to complete 100 hours of community service, but the court is suspending those community service hours. If you can get a job through the city's Ready to Work program, the court will grant you, credit you 50 hours of community service. If you go over to SAC and get your GED at the Women's Empowerment Center at no cost to you, the court will give you another 50-hour credit on your community service. So the court will wait to hear from you, Mr. Martinez. The court is also ordering that you forfeit a weapon in the possession of the Bexar County Sheriff's Office. You need to get down there with no later than 7 days, a week from today, and tender and release any ownership of any forfeit any ownership of any weapons in the possession of the Bexar County Sheriff's Office. And in exchange for your plea today, Mr. Martinez, the state has agreed to take into consideration, in other words, dismiss case number CC 718326, a case in which you were charged with unlawful carrying of a weapon. So that's going to get dismissed. That is the court order, Mr. Martinez. Did you understand it?
Yes, ma'am.
Do you have any questions?
No, ma'am.
Then I'm going to find that you entered into this plea agreement intelligently, freely, and voluntarily. Yes, sir.
I had a question. For the drug test, do I go, because I've been taking one every week, do I go to the same place or do I go somewhere else?
Officer Martinez, who was giving us information about you, Mr. Martinez, she's going to speak to you immediately following the closure of this proceeding. And she's going to tell you how to stay compliant with my court order, which includes that UA, and how to get compliant with the conditions of probation I'm about to issue. Okay. So she can answer that question for you, Mr. Martinez. Okay.
Yes, ma'am.
Okay. Aside from that, do you have any other questions?
A snafu. That sounds like sneezing. You know, it is. I would like the derivation of snafu. Where that? Oh, it's
situations on the law.
Okay.
Yeah. Fouled up. Yeah, fouled up.
Daryl Cooper. You're Daryl Cooper. Sorry, Mr. Cooper. I don't have to tell I don't have to tell you. You know that you got cocaine in your system. Where's his file? Did I give it back to you, Darryl Cooper? I don't have it.
I'm not very good, I still get the release.
And his bond is what? That's Mr. Adams, I guess, is your attorney. What was his bond?
It was $5,000.
Okay, your bond, you have failed this drug test, you have cocaine in your system. And your bond is revoked, it is doubled to $10,000, plus you must have a drug patch as a condition of bond, because the very first condition of bond is do not commit an offense. And illegal use of drugs, cocaine is an offense. So you will be taken into custody. And Mr. Walker, that's you. Come on and get a resetting. You're free to go. You got it? Okay. You're free to go. He's in custody. Yeah. When you flunk the drug test, you were immediately taken into custody. I have Mario Hernandez.
Ready, Jeff?
Come on up. Mario Hernandez, that's you?
Yes, sir.
Present. But Mr. Kelly, your attorney in the state's attorney, does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
We do, Your Honor.
In summary, this indictment alleges that on or about March 10th, 2021 in Jefferson County, Texas, you committed the second-degree felony of indecency with a child. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty, prosecuted for the lesser included offense of okay. What is the offense?
Indecent assault. Class A.
What's the section number, please? I got 22, I guess. Indecent assault 22.012. A person commits an offense without the other person's consent with intent to arouse or gratify the sexual desire of any person. Person touches the breast of another person. This is a Class A misdemeanor.
Correct, Judge.
So let's go back. So the punishment range is not second-degree felony. It's Class A misdemeanor, right?
Judge, I'm sorry. I fill those out based on the allegation, the indictment, on what we're ultimately leading to.
Fingerprinting. Locked. Please write your name and start walking around to have a good culture. That one point. Let's back line the thoughts. Ink it up one more time. Let's back that way.
So. Trying to resolve some of the market. They can put it up.
All right, the, Winter have agreed to, that you would be pleading guilty to lesser included Class A misdemeanor indecent assault, which is found under Section 22.012 of the Texas Penal Code, which carries with it up to 1 year in the county jail and or up to a $4,000 fine. Do you understand the punishment range?
Yes, sir.
The agreement is that you would be placed on deferred or unadjudicated probation for 2 years. Is that your understanding of the agreement?
Yes, sir.
Also fined $500.
Yes, sir.
If I follow that, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this Class A misdemeanor, lesser included offense under this indictment? Indecent assault, guilty or not guilty?
Guilty, Your Honor.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document?
Yes, sir.
Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
Objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes,
Is
sir.
that true?
Yes.
State's Exhibit 1 is made a part of the record for all purposes.
Or later. I'm gonna do your acceptable.
These don't have it. This doesn't have a reporting requirement, does it?
Only on the second offense, Judge.
And thanks for your patience. Just
Thank you.
okay. I think I understand all of this here. How old was the child? 10 years old?
Yes, sir.
So the only difference between this and the second degree felony of indecency with a child is the fact that y'all just dropped the age of the victim, right? As an element.
Yes, sir.
Everything else is the same.
Yes, sir.
Okay. All right. Anything else?
Not from us. Judge.
Okay. It looks like sex offender registration is not required yet.
It's not mandatory, no, sir.
And it didn't get passed in this term, I guess.
No, sir. Not to my knowledge.
Because the statute says it's sexual offender registration is not required, and then it's in parentheses yet. So apparently, for whatever reason, they elected not to. The legislature elected not to change that other code. Well, anything else?
Not from us. Judge.
All right, and the defendant has entered his plea of guilty to this Class A misdemeanor. Is a pre-sentence report waived?
Yes.
Anything else to add? If not, I'm going to find Mr. Hernandez, you have pleaded guilty to this Class A misdemeanor, the lesser included offense of what is referred to as indecent assault. And under section 22.012 of the Texas Penal Code. You have pleaded guilty voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. However, I am going to follow this agreement, defer any finding of guilt, and place you on deferred or unadjudicated probation for 2 years. You are fined $500. There will be terms and conditions of probation, which are normal and customary for this type, a general type of offense, even though I'm wanting to go to sex offender classes and other things like that, that are normal and customary for other types of the offenses. And especially in light of the fact that the complainant was 10 years old at the time of this event. There will be other terms and conditions of probation which are normal and customary for this. Now, you're also going to do 180 days in the county jail. This is a crime of indecency. A 10-year-old child is victimized. You're going to pay a price for irreparable harm to a child on my watch. I just wish it was more. You took advantage of a 10-year-old more than once, according to the probable cause affidavit. And except for everybody just dropping the age, it's a second-degree felony. Plus mandatory reporting requirements for life, I believe. Otherwise. So what this court can do in managing the fair and appropriate remedy that I guess we can, assess, although how do you take back the harm to a child? There is no way. You took advantage of a child. I have no sympathy for you. I have sympathy for the child. You took advantage of a 10-year-old child. Shame on you. You're going to jail immediately, 180 days, as a condition of this probation.
Your Honor.
Anything else?
Yes, Judge, if I may, considering that he's employed currently, will the court allow us to break that up in some way? I don't have something to proffer to the court right now, but I would at least like to ask the court to
Let me just say,
to consider.
Mr. Kelly is one of the most wonderful people I know. And he's a wonderful attorney, as well as just being a very fine, great man. He has children, and I know what he thinks. I know what we all think. You didn't give this child a chance to get ready for your assaultive behavior. And you did this more than once. And I have no sympathy for you. I'm not going to work on your terms, in spite of the fact I would do almost anything for Mr. Kelly. This doesn't have anything to do with Mr. Kelly. He's trying his best to help you, but he cannot undo your terrible misdeed. It was an unnatural act you performed on a child. Shame on you. You're going to jail. The most I can put you is 180 days. And that's what you're getting. That's what we call justice under these circumstances. Unfortunately, we can't undo the assault that you performed on a 10-year-old child. Shame on you. Anything else? That's, in all due respect, if it was any other kind of circumstances, Tom, but I feel sorry for that child. That is all.